Hello, 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 everybody. Welcome, welcome. Let me get everything set up here. Hopefully, hopefully it's working. We shall see. Hello, hello, Big Papa. Hello, 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 everybody. Uh, this is one of my pop-ups, pop-up lives. Hello, Nancy Okra. Good morning. Hello, Alice. Oh, I hope everyone's doing well today. Hello, Miss Betharoni. Yes, yes, we are doing great. Nail cam. Here's a nail cam. Oh my gosh, yeah, I think that's a little fun. Got a little drama. We're hinting at fall here. So there's that. Hello, June Marie. Hello, hello. I had promised to start coming over here more frequently. So this is the beginning. Oh my gosh. Yes, yes, yes. Crazy morning already. Oh, I know. I know. I'm still kind of waiting for all of the information to come in. Like, I feel like we haven't gotten everything yet. So I'm just kind of like, what's happened? What's happened? But yeah, there's been a lot going on. A lot going on. What I wanted to do though this morning is such that it is I am starting this new series just over here for YouTube, everybody, and where I'm going to be going through the executive orders. We've been talking about this for quite a while. We know there's a lot of executive orders. I don't know, maybe 225 now, 250, who knows? Because I don't, I stopped really paying attention after 200. But I wanted to go into the executive orders that are a big part of the litigation that's been going on. So this one for sure got me ready to go. I was like, let's do this. This is the labor management executive order, right? So right now, I believe there's 8 lawsuits that the government has filed against employees, against unions, in order to do away with the contracts that they have. So if you've got a collective bargaining contract going on, there are 8 cases where the government's trying to, put those in null and void. And the reason they've done that is because of this executive order here, which was published March 27th. And what they did was they came in and changed the definitions of labor management relations in the US Code. They came in and kind of took apart and put back together an executive order that was set out in November of 1979. So by coming in and changing all of these different pieces, it allowed them to go forward and ask various places and say, we're not going to respect that collective bargaining agreement any further because the Prez has decided to make it a national security issue, which we knew that's kind of the mode that he's using in order to kind of take over everything. So that's very distressing. Quite distressing. Yes, happy Friday. Happy Friday. Um, yes, Kaya, thank you. These are all publicly available, right? So this is the executive order itself. So this is, you can go to the White House and pull this up, or the Federal Register. And then also the U.S. Code. You can go look that up yourself as well. None of these documents are privileged in any way. I just will try to help to understand it because they're kind of crazy. So welcome in, everyone. I'd like to, oh my gosh, everyone, this is still, I'm trying to stay positive, but this one's a tough one. This one's tough to stay positive on. But let me get a sticky note out here, and I'll ask everyone here, how should we label this? Should we just label this an executive order here, or a labor relations executive order? What do you think would be best here? Hello, Team A football. Hello. Oh my gosh, it's football season already. I'm like, isn't the baseball still going? I don't know. I don't pay attention. I probably should, but I don't. So forgive me. So let's go ahead and just do an overview, I think is what I'd like to do here. Overview of executive order. Oh my gosh, this one's a tough one, everyone. And again, these keys are all going to have to go up to SCOTUS, and who knows what they're going to do with that. Maybe SCOTUS is okay getting rid of labor relations. I really don't know anymore. I mean, all bets are off. So this is Executive Order 14251. And again, it's labor management relations here. I'm not sure how many of you all have been involved in collective bargaining or anything to do with unions as you have done your work over the years. But of course, our unions are always trying to fight for more of something, whatever that something may be. But this is going to be a bit rough here. I can only guess that our courts, of course, are going to say, "Wow, hi Congress." That's one of the things that I think we really should remember as we go through this, everyone, is when we're going through this. This is a U.S. code, right? So U.S. code, and they're going through and changing things, and it's like, well, who writes the U.S. code, right? So it's not the president. Hashtag it's not the president, because the president doesn't make law. And so if you're going in and changing definitions of stuff and so on, you still are, making law. You're changing law. And so the president doesn't write the U.S. code. So that's kind of how I'm viewing it right now, is that it's going to take some time to, get this in front of the court, and the court to say, well, you don't have that ability, and then for all of the appeals to happen and such. So at the flea market, oh, I love it. I love it. Right, labor relations. And include something about unions if that's what it's about. So, right. I think that's fair too. So we'll just put unions in here, and also because the lawsuits are about collective bargaining, we'll just kind of add that in here. Collective bargaining. Right. Bargain. Uh-oh. Is it GAIN? Oh my gosh. That's what it is, right? Bargaining. That doesn't look right. Oh my gosh, everybody. Oh, my spelling. My spelling's terrible. All right, well, hopefully that's correct. Oh, really? Really, for your union back in the day? I love it. Oh my gosh, Big Papa, you spelled bargaining for me. Oh my gosh, thank you. saving me today. I appreciate that. Yowzers. All right, thank you so much. I appreciate that. Oh my gosh. All right. Well, I use spell check so much, everybody, and so I've unfortunately become reliant on it. All right, let's start diving in here. And as I go through the documents, if you're new here, I have a ton of amazing moderators who help me so much. And I just come to explain stuff. I'm not really making any kind of arguments one way or the other, or endorsing or not endorsing anything. I'm just, going through what the law says and explaining it. So as I do that, my moderators will keep track of what's going on. So hopefully everyone will be respectful, because I'd appreciate that quite a bit. But I'm going to be focusing on the documents as I go through here. And then I will be kind of glancing back and forth between questions and comments. So just to give anyone who's new a heads up here. All right. Thank you, Star. Thanks. Thank you, everybody, for helping me with that. It's nice to be able to say, hey, can you help me? And then people do help. I appreciate that. All right, so let's go through this. And again, this is kind of broken up because what they're doing is changing different pieces of law that's already out there, or this executive order. So we'll just kind of walk through this and see how it plays out. All right, so here we go. We have executive order 14251, and I always make sure when I'm going through executive orders is that I pull them from the Federal Register. If they're not on the Federal Register, I'm not confident of exactly when they come into play. With this administration, there's been some problems with that. So I always go to the Federal Register, and they set out here, when it actually went into the register. So this was made public March 27th, but not included in the register until April 3rd here. Brian, yeah, so Brian's handle, oh my gosh, everybody that was so fun yesterday. That was so fun. So yes, so his handle is, I think this is how Brian, I think it's Brian, no DC. All right, I think that's it. And if it's not, I'm sorry. That's my best guess. So if anyone hops over there and then comes back, you can confirm with us. Brian is another content creator who does amazing work, an attorney, and we have been having a lot of fun doing some lives together, going through the lawsuits that are going on. All right, so let's go ahead and dive in. We've got exclusions from federal labor management relations programs. So again, they're setting out what they're wanting to eliminate from what's already in place. Now, if you'll remember, we had someone who was fired from the position off of the Federal Labor Relations Board, FLRB, and so they fired that person even though they had a couple more years left on the contract. And I believe they've not been able to get a quorum because of that. So they've not actually been able to go through and sort out any of their labor cases because they don't have enough people on the board. So it's kind of had, ongoing issues. So that's been argued back and forth quite a bit. So here we go. By the authority vested in me as president by the Constitution and the laws of the United States of America, including Section 7103B1 of Title V and 4103B of Title 22, which again are just code sections setting out what's allowable. And let me just give you a little example here. So this is 22 U.S. Code, Section 4103, right? And so the citation here is to subsection B. So exclusion of subdivisions, and the president may, by executive order, exclude any subdivision of the department from coverage under this subchapter if the president determines that, one, the subdivision has a primary function intelligence, counterintelligence, investigative, or national security work. All right, so again, they're setting that up. And so we need both. Two, the provisions of this subchapter cannot be applied to that subdivision in a manner consistent with national security requirements and considerations. So boiling all of that down, it just means if the president feels that there are pieces having to do with national security, he can come in and kind of strike out whatever it is that he wants. And that's exactly what they've done with this executive order. All right, so there's a lot going on here. All right, it's hereby ordered. Section 1, determinations here. Sub A, the agencies and agency subdivisions set forth in Section 2, so here, of this order are hereby determined to have as a primary function, that's important, intelligence, counterintelligence, investigative, or national security work, right? So he's putting that language directly back into this piece, right? Because we just read that he's got the authority to do that. It's also hereby determined that Chapter 71 of Title V United States Code cannot be applied to these agencies. Now let me just pull that section real quick so that we know what's being talked about. Here we go. Oh, oops, no, there we go. So, 7103, this is again out of the US code. So we've got 7103, let me make sure I get the number right. 7103B1. I don't know, I just was spacing out for a minute there, everybody. All right, so let's just take a look here. We've got, where's the definition? Here we go. B1 back here at the very end. The president may issue an order excluding any agency or subdivision thereof from coverage under this chapter if the president determines that A, the agency or subdivision has a primary function, intelligence, counterintelligence, investigative, or national security work, and 2B, the provisions of this chapter cannot be applied to that agency or subdivision in a manner consistent with national security requirements and considerations. So again, this is all about what the president deems is a national security issue, all right? So 7103 is a set of definitions that we need. All right, so through those two statutes, which clearly somebody in his administration has been looking at this, out of Project 2025, which is exactly what this is. So the Heritage Foundation have already kind of pulled a little bit of the corner out and said, well, if we ever want to get rid of labor management issues, these are the sections of the code we can use, all right? So there we go. United States cannot be applied to these agency subdivisions in a manner consistent with national security. So that's exact language out of the code. All right, and then here's B, the agency subdivisions set forth in section 3, so on the next page of this order are hereby determined to have as a primary function intelligence, counterintelligence, investigative, or national security work. So as we go through here, we can see like, well, is this having to do with national security or not? And so we can make those guesses, but in the end, it's up to the president according to the code here. It's also hereby determined that subchapter X of chapter 52 of title 22. So that, I keep calling it subchapter X, but it's 10. It's subchapter 10 here. The United States Code cannot be applied to these subdivisions in a manner consistent with national security requirements and considerations. All right, so again, this is just all about giving this kind of blanket authority to the president when it comes to a national security issue. If they determine that, they can kind of cut pieces out here. A couple minutes ago, it didn't post. I had to do a test. Oh, no problem, Alice. Sometimes it takes a couple of minutes for it to come in as well. I've noticed that on some other lives that I've been on. All right, so here we go. Determinations, and we've cited the law where he has said I can do what I want here. All right, so we're also, I think it's important to note, we're not changing definitions. We're not changing law. We are pulling out pieces that we think are national security areas. All right, so keep that in mind as well. Here we go, additional national security exclusions. So this is where the executive order comes in. So section 2 here, and that's again subchapter 10. Additional national security exclusions. Executive Order 12-171 of November 19th of 1979, as amended, is further amended by, and this is where we're going to start getting into the weeds of what the changes are that he's wanting to do here. So let's take a peek here at the executive order that was done in November of 1979. So this was set out. So we've got, again, I'm not going to go through all of this, but by the authority vested in me as president by the Constitution and statutes here, 7103B, right? So that's the exact same language he used here with what he was saying. And he's doing 1-1 determinations, right? So they're really kind of cutting and pasting. I think it's important to note that here, all right? So they're talking about picking up section 1-101 and adding and section 1 through 4 after sections 1 through 2 in both places that the term appears. So we're adding another section here. So that's all that he's starting with. We've got, again, 101 here, 102, and then up here there are exclusions 1 through 2. And so this administration's wanting to pull exclusions 1 through 4 here. So that's the additions made. And then we've got 1-201, Information Security Oversight Office. So this stuff until we get to, which one is it? 402. So it's 400 where the most significant changes are that he's wanting to add here. All right, so is that kind of making sense, everybody? We need to kind of look at the overview because we're not going to know exactly, what we're dealing with. But what they're trying to add as exclusions, we can look at that. Department of State, next, Department of Defense, except for any subdivisions excluded pursuant to Section 4 of the Executive Order of March 27th of 2025, which is this executive order here. So he's focusing, putting that Department of Defense back in here to say, look to the executive order, which is what we've got here from Jimmy Carter, all right? Next, we've got the Department of Treasury, except for the Bureau of Engraving, Department of Veterans Affairs, Department of Justice, agencies or subdivision of the Department of Health and Human Services over here. So again, this is what we're talking about for exclusions from the labor management relations issues. All right. So people that are like, oh, we need smaller government. He's like, no, we're going to make it bigger. Make it much bigger. So agency, subdivision, Department of Health and Human Services, so Office of the Secretary, Food and Drug Administration, Centers for Disease Control Prevention, Administration for Strategic Preparedness and Response, Office of the General Counsel, Office of Refugee Resettlement Administration for Children and Families, National Institute of Allergy and Infectious Diseases, National Institutes of Health. So again, these are exclusions when we're talking about labor relations here. And again, I'll show you where we're going right here. See this? Exclusions are set out. So he's adding these section 4 here, right? We had 1 through 2, and now we have 4 set out. And then agencies or subdivisions of the Department of Homeland Security. Oh, and you might think, well, that's enough for exclusions, but then you'd be wrong. Then you would be wrong here. All right, here we go. Office of the Secretary, General Counsel, Policy Plans, Management here, Science and Technology Directorate. Again, this is where all of those labor relations and management pieces now are. These are places excluded from that. U.S. Citizenship and Immigration Services, Immigration and Customs. So now we've got ICE excluded, U.S. Coast Guard, Cybersecurity Infrastructure here, Federal Emergency Management. So that's FEMA here. Next, we've got agencies or subdivisions of the Department of the Interior, Office of the Secretary, Land Management, Safety and Environmental Enforcement, Ocean Energy Management. All right, so those have been added. These again are exclusions here, everyone. Hello, hi Gia. Tracking executive orders, legal challenges to Trump's executive orders. Exactly right. Thank you, Anne Marie. Yes, so I'm just going through this particular executive order today on labor relations. So that's 408, 1-409, Department of Energy, and that's all they needed to put here, except for the Federal Energy Regulatory Commission, and that's probably because it couldn't be excluded. The following agencies are subdivisions of the Department of Agriculture, Food and Safety Inspection Service, and again, we're removing this labor management umbrella. International Trade Administration, Department of Commerce, Environmental Protection Agency, United States Agency for International Development, Nuclear Regulatory Commission, the National Science Foundation, The United States International Trade Commission, the Federal Communications Commission, the General Services Administration. And again, as a side note, remembering that he is saying these need to be done this way because we've got national security as an issue here. With these different areas. All right, so 1419, following agencies or subdivision of each executive department listed in section 101 of Title 5, United States Code, Social Security Administration, and the Office of Personnel Management. So we've got Office of Chief Information Officer and any other agency or subdivision that has information resources management duties as the agency or subdivision's primary duty. So this is a catch-all phrase and maybe too broad to make it past judicial review. So we'll see. And next, we're bumping down to 1-499. Notwithstanding the foregoing, nothing in this section shall exempt from coverage of Chapter 71 of Title 5 United States Code. So this is where they're saying we're putting exemptions in all over here, but these are the ones that are not, just for clarification. All right. So nothing in this section shall be exempt from coverage from labor relations protections. All right. So A, the immediate local employee offices of any agency, police officers, security guards, firefighters, provided that the exclusion does not apply to the Bureau of Prisons, subdivisions of the U.S. Marshal Service not listed here up above, or any subdivisions of the Department of Defense or Veterans Affairs for which applicable secretary has issued an order suspending the application of this section pursuant to Section 4 of the Executive Order. Here. All right, so that was kind of in the weeds, everyone, of what we were looking at. So let's go forward down here. The changes make a little bit more sense. So those are the exclusions, and now we're into Section 3, Foreign Service Exclusions. So again, we have 12171 as the executive order that's being referenced here, which was signed by Jimmy Carter. All right. It's further amended that in the first paragraph, adding section 4103B of Title 22 and Title 5, and adding subchapter 10 of Chapter 52, Title 22 after Relations Board. All this is doing is making sure that what he just set out as exclusions are incorporated properly into the different pieces. All right, so that's all this means. Adding after section 1-102 a new section of 1-103 that reads, the department subdivisions set forth in sections 1 through 5 of this order are hereby determined to have a primary function: intelligence, counterintelligence, investigative, or national security work. Again, putting in and defining this is a security situations, national security, which means I'm going to take control and power over it. It is also hereby determined that subchapter 10 of Chapter 52 of Title 22 United States Code cannot be applied to those subdivisions in a manner consistent with the national security requirements and considerations. The subdivisions set forth in sections 1 through 5 of this order are hereby excluded from coverage under subchapter 10 of Chapter 52 of Title 22 United States Code. And then next, adding a new section here, 2B of this order. All right, so this is a lot to take in. All right, if you're thinking to yourself, well, what does all of this mean? This means that we are adding and subtracting different levels of coverage when it comes to labor relations. All right, and he's choosing who's getting coverage, who's not getting coverage. And that coverage could be collective bargaining agreements. It could be union representatives. There's all kinds of things where unions and labor relations can come in and help. But he's saying you're not going to be included, listed and listing them out. All right. So that's what's happening here. Next, 1 through 5 subdivisions of Department of Employing Foreign Service Officers. All right, subdivisions here, each subdivision reporting to the Secretary of State, Deputy Secretary of State, Deputy Secretary of State and Management Resources, Undersecretaries, Arms Control and International Security, All right, so no labor relations protections for you. Under Secretary for Civilian Security, Democracy and Human Rights, again, no protections here either. Secretary of Economic Growth, Energy, Environment, um, under Secretary here, also for Political Affairs, Public Diplomacy, and U.S. Embassy, Consulate, Diplomatic Mission, or Office providing consular services. All right, right. Let's talk about this. Mo girly girl, let's talk about this. So what we have are different divisions of federal workers, right? So let's just use the Department of State. In the Department of State, there are going to be a ton of employees, right? Well, maybe not at the moment because most of them were fired. But are you following me with that? We've got a lot of federal employees included in here. And then what the federal employees have done, depending on where they're at, like for example, the Department of Treasury is probably the most well known. The Department of Treasury has all of their employees and they're unionized. They're covered by the unions and the protections set out in labor management relations and all of the different programs here. All right, so for example, 5 U.S. Code Chapter 71, Labor Management Relations. That's all included here. And so what he's doing now is he's saying, excluded from those labor management relations are going to be these additions. Yes, he can do that, and he's doing that by using a couple of different statutes. The first statute here is saying exclusion here of division. So let's start at A, departments and agencies affected. So 22 U.S. Code 4103. This subchapter applies only with respect to the Department of State, the Broadcasting Board, the Governor, Agency for International. But let's go down here. Exclusion of subdivisions. The president may, by executive order, exclude any subdivision of the department from coverage under this subchapter if the president determines that one, the subdivision has a primary function of intelligence. And again, so what he's saying is that the Department of State's primary function is intelligence, right? So that's where the legal questions come in. Is that true? Or what about, let's go down here, Treasury. The Department of Treasury is super pissed about this. All right, so let's go to the Department of Veterans Affairs, right? If you think about the Federal Department of Veterans Affairs, is their primary function intelligence, counterintelligence, investigative, or national security work? Right? So that's the question I posed to the chat here. What do we think? Are we, is that their primary function for the Department of Veterans Affairs? To security, counter security. Hello? Is anybody there? Anybody out there? Hello? Take a minute here. I know you're there. I can see the numbers. You just don't want to, you don't want to participate today. Everybody's got their cameras off. All right. Well, no problem. The answer is, I don't believe so. What they're going to do then, and what they are doing, is they're going into court and they're saying if he wants to use this section of the code, he is not in compliance because the primary function of the Department of Veterans Affairs, right, is not, oh, no, don't worry about it, anybody. No, don't worry about it, BC. I'm giving you all a hard time in there. Right, that's not the VA's role. And so, but what he's done is he's added a whole bunch, right? We've got this whole section that I had gone through here. So the DOJ, that there may be some security counterintelligence involved in the Department of Justice. It's possible. Here's some other agencies. What about the Food and Drug Administration or the Administration of Strategic Preparedness and Response, right? So he has to fit what he's wanting to kick out of labor protections under this idea that there's a national security or intelligence work. And the provisions here can't be applied to that subdivision in a manner consistent. So it has to be both. Not only is the primary function intelligence, but also We can't have any kind of inconsistencies with national security requirements. So it's a broad swipe. And as with all of this stuff, because when we get these executive orders in, everyone, the first thing we look at is like, all right, well, which rules are not right here that he's trying to use. And that's the big one here, all right? So underneath the authority he's been given, he's setting out that these all have primary intelligence functions for national intelligence. Is it being challenged? Yes, it is. Yes. And that's one of the reasons I brought it to go over today. We have about 8 lawsuits right now by multiple unions, employee unions, federal employee unions, who've said that this isn't right. This isn't how the law works. This isn't how your power works either. And the executive order is way too broad. And then I would remind everyone too, you might say, well, maybe the courts aren't, going to follow that. But if we just look back to an example of what they've already done, all right, so the exclusions from federal labor management relations here, again, this was Jimmy Carter back in 79. They did set out some exclusions. They set out some agencies like U.S. Secret Service Uniform Division, the Office of Special Assistance to the Secretary, National Security Issues, Office of Intelligence Support, Office of Assistant Secretary, Enforcement and Operations. So you can see when they're listing the exclusions out here, you can see how we might have some intelligence issues, right? Criminal Enforcement, Bureau of Alcohol, Tobacco, and Firearms, Office of Investigations, U.S. Customs Service. So this is what, Carter put into place. And we compare that to here, what Mr. Orange is, I don't have to say Mr. Orange anymore, we're over here, and apply that to what Trump's doing, right? And this is what we have: Department of Treasury, right? Department of Veterans Affairs, Department of Justice, which could be maybe, but you'd probably want to be more specific. Department of Health and Human Services. See the difference between those two roads. And so when Congress set out rules, we have an example of what this is supposed to look like. And then we have this huge overreach by this administration of trying to kind of sneak this stuff in so that there aren't labor protections for federal employees. All right, is that making sense? You understand he's not. Well, right, exactly, Kaya, exactly. Needs to sue separately against this. Correct. So each group of employees that are being affected will have separate lawsuits, right? Because they're different unions. So we have, again, the Treasury unions, like, man, they're hardcore, and I totally respect them for that. I think the Treasury union actually has 3 lawsuits going, and not just over this. So the employees in the Treasury Department, the Veterans Affairs Department, and just as a side note, we have had problems in the past with the Department of Veterans Affairs being handled illegally and some corruption. We have had those issues before. And so here it's like, well, we're going to take away labor protections from the Veterans Affairs Division, right? And again, is their primary purpose intelligence? No. Which again, over here, if we look to see what Carter included, he said U.S. Army Intelligence Center and School. Now that makes some sense. This one, not so much, right? Waste, fraud, and abuse. Oh, I know, right? So, all right. Oh my gosh, this is a tough one, everyone. This is a tough one, and also would not be one I could do actually on a live over on the TikTok. So that's why I'm over here, and we'll continue to be over here with these executive orders. Now, moving forward here, again, these kind of side notes with the U.S. Marshal Service and such, they're just adding those in just in case. But now we're up here for the foreign service exclusions again, and they're saying, again, all of these cannot have any kind of labor protections because they're all national security. Now, if we take a minute though and we think about that, everybody, we're like, why is he even doing this? Why is this national security? And the question or the issue is would it be possible then for unions or unionized employees to somehow breach their national security requirements if their main purpose is intelligence? If that was truly their main purpose, then they're in their own field of confidentiality, right? And so that information going to and from unions or labor relations, that information can't get out, like under something like Doge, where they came in and just took everybody's information, right? Because these would be set aside and not able to be put under labor relations, right? So they're saying these different places need more protections just by the executive, and because of that, you get no labor protections. All right, so next here we have the U.S. Agency for International Development, all overseas missions and field offices, all of them, right? And so you can see how this administration, again, is taking this very broad stance on national security. Like everything is a national security issue. And that's what they're doing here, all right? So all overseas missions and field offices, national security. Each subdivision reporting directly to the administrator, national security. Each subdivision reporting to the deputy administrator for policy and programming, also national security, right? And so on and so forth. In his mind, right. All people are threats. That's true. That's true. So, but again, I think too, one of the things that I've been trying to talk about quite a bit is with this administration, with Trump in particular, is that he's a micromanager, right? We know that based off of any of the biographies done, or even listening to him talk about his own crap, Sorry, I've listened to too many tapes. He's a micromanager. He wants to have every single inch of his own business to be at his own whim, right? So all of his businesses, properties, all of that stuff, he micromanages the crap out of it. And that's why there's like so many problems, and why New York was like, dude, we're going to catch you because there's too much stuff. This is the definition of micromanaging. But what are we micromanaging here instead of his business? We're micromanaging national security and running the country, right? So he's saying each and every single one of these, he is now in charge of, him being the executive branch. So the president's now in charge because the unions are getting bumped out because we're excluding all of these people because he thinks there is an intelligence issue going on. All right? I can't stand him. I know. So anyway, also though, to put this into perspective when it hits the courts, everyone, is that, the courts have read through these sections of the law. They have examples before as well. And they know when there's been overreach. Will SCOTUS also acknowledge that? And that question, I'm unsure, everyone. It seems like half of SCOTUS wants to submit to a higher authority. And, I don't know exactly, well, I've got my own ideas of where that comes from, but Catholic school. But anyway, so maybe they will be like, okay, yeah, let's make a change. Let's let one person dominate all of the other divisions here. So we just don't know how it's going to go down. Section 4, delegation of authority, and that's my own opinion, everybody, by the way, just to clarify. Delegation of authority to the Secretaries of Defense and Veterans Affairs. This is another thing. He's micromanaging the secretaries so much. I don't know how Pam Bondi's getting anything done because she's being micromanaged within an inch of her own life. Comments to myself about that, I understand. Intelligence issues that he's like, Nancy. Well, yeah, although there's so much truth in that, right? He doesn't have a background in this. He put national security papers marked classified in his bathroom. Like, I feel he doesn't really have a good grasp of what's important and what's not. All right. So we've got delegation of authority secretaries. So he's saying we're going to put more work on the secretaries of Defense and Veterans Affairs because they respond directly to me. So again, I can control all of this. So subject to the requirements of subsection B, the Secretaries of Defense and Veteran Affairs are delegated authority here to issue orders suspending the application of sections 1-402 or 1-404, because those can be suspended. I'm not sure if he is saying that only those two secretaries can do it or not. I'm not even sure how he's putting that. But again, setting out who has the responsibility. Right. Oh my goodness gracious. All right, B here. An order described in subsection A of this section shall only be effective if, and then they're putting parameters on the enforceability of this executive order again. 1, the applicable secretary certifies to the president that the provisions of the Federal Service Labor Management Relations Statute can be applied to such subdivisions in a manner consistent with national security requirements and considerations. Again, number 1, you need to go and talk to him. Now, again, we've got over 200 executive orders, and in almost all of those orders is this request of information to be given specifically to the president. And I think that's because he doesn't understand where all of the briefing and information that he gets comes from. I don't think he recognizes that he's already getting this information, but it goes through different channels. So because he doesn't understand it, he's like, I'm going to designate this person and this person to give me information. And they're like, well, you already get it. And he's like, I don't care. I don't trust them. I only trust these 2 people. And now you've got 2 people, again, running like this entire show here and trying to get that information to him. Number 2, such certifications submitted for publication in the Federal Register, which is required here by law. So section 5, delegation of authority to the Secretary of Transportation, right? That was the reality show guy, right? A, the national security interests of the United States in ensuring the safety and integrity of the national transportation system require the Secretary of Transportation have maximum flexibility to cultivate an effective workforce at the Department of Transportation that is adaptive to new technologies and innovation, where collective bargaining is incompatible with that mission. The Department of Transportation should not be forced to seek relief through grievances, arbitrations, or administrative proceedings. So we'll go ahead and highlight this because this is just clearly saying we don't want to have any kind of union boundaries. So collective bargaining, which is bargaining between labor and management, they're saying, no, you're just going to slow us down. And then you say, well, why? Well, because the system requires maximum flexibility because of national security. So the union is interfering with national security by offering protections and collective bargainings to federal employees. So that's pretty major here. Yikes. Next, the Secretary of Transportation is therefore delegated authority under Section 7103. Again, these are definitions to issue orders excluding any subdivision of the Department of Transportation, including the Federal Aviation Administration from Federal Service Labor Management Relations. Can you imagine what it would be like if the FAA didn't have any protections at all for their employees? I mean, just as a general question, from what we've seen over the last few months with the FAA and what's going on, the minimal protections, they're like, we're taking all of those away. And it's going to be solely at the behest of the Secretary of Transportation. And that's the other thing too. We're not talking about a committee making these determinations about all of the federal employees. We're talking about one person is going to make the decisions. No union, no protections, none. It's just going to be the Secretary of Transportation. Right. So, in any provision of the law with respect to any Department of Transportation installation or activity located out of the 50 states and the District of Columbia, this authority may not be further delegated when making the determination required by these sections of the code. Secretary of Transportation shall publish his determination in the Federal Register. Now, again, just by adding this, his determination is saying, I'm writing this specifically for this person here. The employee should have protections. Well, something, right? There should be something. And, Trump's not known for his, accommodations when it comes to employees. So, you know, I think it's important to note this. This is what's going on here. I also think it's incredibly important to note that when the next president comes in, and some people are like, he's never going to leave. Like, he'll leave one way or another. He's going to be leaving. That the first thing you do on day one is that you pull this, right? So this is going to this executive order will be null and void after that. So that'll happen immediately. And so then everything's going to get shuffled around again. And the whole transportation section of this is going to have to get reorganized because this order's been rescinded. But this order is really only for Trump and his designated people. So it's almost like his own personal setup now. Oh my gosh, Kaya, yeah. For the people who are left. And those who are left are like, we got to get out of here. So, and that was such a huge piece of Project 2025 for those that have read it. And, that's like half of the manifesto is pulling federal employees out, restructuring, and then putting loyalists in. Like, that's the whole backbone to how to overcome. They want to drive out the federal employees. Yeah, exactly right. Exactly. Yeah, it's pretty awful. It's pretty awful, but fixable. It's fixable. So this is kind of foreshadowing the next couple of years are going to be rough. And again, we've got 8 lawsuits filed already, and they were slow coming too. So I think there's going to be probably another rush of labor relations lawsuits coming because you could see all the different departments that are being affected by it, right? So I think more are going to be coming in pretty soon with that. And then it just, boom, you rescind it on the first day. But there's no way, in my opinion, either, that they're going to be able to reorganize all of this in such a short period of time. So not everything is, going to be able to be done quickly. That's the biggest thing right behind. Well, right. See, we've got our hot topics, right? We've got our 1, 2, 3, and then down a bit further, but no less important, honestly, are all of these other protections that are being taken away. And, one thing that I don't want anyone to miss out on is all of the other stuff. There's a lot more going on here than just habeas corpus. And it's this, again, pieces of micromanagement that are weak in front of a court, but something that we need to be aware of. Yeah, exactly, VC. I mean, at-will employment, come on. There's a reason why we don't do it at the federal level. All right, here we go. Implementation. So this is where we're going to have to figure out how quickly this is going to happen. With respect to employees and agencies or subdivisions thereof that were previously part of a bargaining unit but have been exempted under this order, so they're no longer part of that, each applicable agency head shall, upon termination of the applicable collective bargaining agreement. So this is what's going to happen after they get rid of the collective bargaining agreements, which again are essentially a bill of rights for workers. All right, that's really what it comes down to, and protections for management as well. So don't get me wrong, this isn't just about, all right, we'll pay them, an indefinite amount of money per hour. No, it's not that. But it's also the managers are like, well, at this point, termination is appropriate, or this kind of thing happens, then this is what you can do about it. So it's for both sides. Although I feel that that's not important here. First, reassign any such employees who performed non-agency business pursuant to section 7131 here of the code performing solely agency business to performing solely agency business. So removing non-agency business to solely agency business, and terminate agency participation in any pending grievance proceedings under section 7121 here. Exceptions to arbitral awards, so if you win your arbitration, that's okay, or unfair labor practice and proceedings here. So the unfair labor practice and proceedings can go forward. That's, whatever, that involves such employees. All right, so grievances are done. Any kind of stragglers are allowed, but then that's it. Oh my goodness gracious. Additional review within 30 days of the date of this order, and the date of this order was March 27th. The head of each agency with employees covered by Chapter 71 of Title V shall submit a report to the president, again, all right, that identifies any agency subdivisions not covered by this executive order. So he's saying, who did I forget? Who is left that I did not put in here to be exempted from having to work with labor relations? All right, so that's the first. And that have a primary function, intelligence, right? So he's using that language again in the statute. So who's left that has a primary function of intelligence, counterintelligence, investigative or national security work, applying the definition of national security set forth here, and for which the agency head believes the provisions of Chapter 71 cannot be applied to such subdivision in a manner consistent with national security. All right, so this is his, and if I missed anybody, let me know. And we'll just use that same language to go ahead and pull any protections. Hate it when they can't control how much or little percent. Oh, I know, exactly. Removing bargaining, paying them less. Right. I mean, right. My goodness gracious. All right. And this is that anyone I've left out piece. And as we went through all of the different sections that are so broad, again, like U.S. citizenship and immigration services, think about what they do for services, but he's claiming here that the primary function is intelligence. And, he may think that's true. He may think the primary bit is supposed to be intelligence, not recognizing that that's not what it's for. Right, exactly. All right, general provisions, and this is just that regular wrap up, the boilerplate piece that says nothing in here should be conflicting with law that's already out there. And also what we use in court, we're like, well, it is conflicting, right? Nothing in this order shall be construed to impair or otherwise affect the authority granted by law to an executive department or agency or the head thereof. So again, we're only in the executive department, or the functions of the Director of Office Management and Budget relating to budgetary administration. Again, another executive function here. This order shall be implemented consistent with applicable law, and that's another piece that's going to come back because it is not consistent and subject to the availability of appropriations, which again is saying Congress can give them money, but yet with this administration, that doesn't mean much. This order is not intended to, and does not create any right or benefit, substantive or procedural, enforceable at law or in equity by any party against the United States, its department, agencies, or entities, its officers, employees, or agents, or the other person, right? And then it's signed. Let's just take a look at that signature. What do we think about the signature, everybody? I feel like I've seen that. All right, that's my moment of, oh my gosh, this sucks. petty moment. Oh my gosh. All right, so that's the exclusions from federal labor management relations programs set out. It's not that people haven't done it before or that you can't do it. but you have to do it within the confines of the law. And that's not what's happening here. Again, the key piece is that their primary purpose is intelligence, and that's what gets it into that national security realm. If you can't get into the national security realm, what I've noticed with this administration, and I'll just share this here, this is how you get around it, right? So here's our road to the road to what do we want? How about Trump land? Trump land. There we go. All right, first thing you do is you see if you can declare an emergency. All right, so is it an emergency? Somehow, loosely. If it's not an emergency, then you see how can you tie it somehow into national security, which is not really defined. National security. All right, or is it somehow tangled up with national security? All right, how do we stretch it so that we can pull national security in? Number 3, foreign relations. So perhaps the national security piece isn't able to be stretched that far. So does it have anything to do with any kind of foreign relations? And that could mean anything. It could mean just, well, foreign relations, people from that country come into the United States. Boom, foreign relations. So now we can do whatever we want to the agencies and stuff. All right, so this is the big 3. Number 1, does it qualify as an emergency? Number 2, can we somehow force it into a national security box? And number 3, does it have anything to do with anybody other than the United States at all? At all. Which he kind of was dabbling in a little bit here, because that's how you get total control. All right, now Congress can come in and undeclare the emergency. Like, nope, that's over. Congress can come in and say, nope, that's not part of national security. They can also say, nope, that's also not part of foreign relations. But where's Congress, right? They're somewhere else other than coming in here. Right, always thought it was his people, not him making the orders. Well, I think the technical language of it, without a doubt, is being done by some kind of legal team, right? So it could be like John Eastman sitting there whispering to Stephen Miller. You know, there is clearly someone with some extensive legal knowledge involved in all of this in order to pull the words together in a way that makes it, you know, semi-soft or semi-firm. Semi-firm to go into court and try to argue the BS, right? You got to have at least a semi-firm case. That's not working properly. My bad. What's the word I'm looking for here, everyone? That's not the right word. Semi-legitimate, semi non-frivolous. I've got to get rid of the word semi. Oh my goodness. I'm sorry about that. That was not professional. Anywho, but that's how they get it in front of the judge and give SCOTUS something, some teeny tiny bit to kind of hang their hat on, if possible. Gotta go. Yeah, take care. So, and this is what I've got for us today, everyone. This is, again, last minute. All of these executive orders I plan to go through and explain as best as I can, but this will only be a series over here on the tube. So the executive orders, I will not be able to get any of this language into the talk. So thank you for coming by, everybody. Hopefully this was interesting and you've learned a little bit. And when you see more of the lawsuits coming down regarding collective bargaining, you really know what the whole crux of the issue is. So oh, you're very welcome. And I'm continuing to update the closet docket. as we go through. So we'll be doing some more executive orders. With that, I will go ahead and sign off for now, everyone. Have a wonderful day. I am over on the tube answering comments, and then over here, of course. So any questions, feel free to leave a comment, and I will try to get back to you. So have a good one, everyone. Happy Friday.